Arbitration is the adjudication of dispute between the parties, either by an independent person or by a group of persons appointed by the consent of parties. The essence of arbitration is the judicial minimalism and the party autonomy. The objective behind the enactment of arbitration is to achieve the fair resolution of dispute with minimum expenses or without unnecessary delay. The essence of arbitration can be found in the Indian text also. In the ancient India, a text Bhadranayak Upanishad written by sage Yagvalyak has mentioned the arbitration in primitive form. He mentioned the three aspects of arbitration. First, Paga, second, Kula, and third, Sreni. Paga means an independent tribesman adjudicate the dispute between the tribes. And second, Kula is resolution of dispute among the family by head of the family. And third is the Sreni. Sreni, ancient text says, this is the group of merchant. This is the association of merchant. Sreni is basically association of merchant. So, the dispute between the merchants decided by the group of merchants or the head of merchants body, that is called Sreni. So, we can find the traces of arbitration in the primitive form present in the Indian society in the ancient period, and as well in the panchayat system also, which is applicable even today in the remote villages of India. That is, the traces of arbitration can be found. If the modern concept of arbitration is concerned, the Britishers has enacted the law of arbitration in 1899 based on the British system of arbitration. But the first modern concept of arbitration is the Arbitration Act of 1940. But before that, in the Civil Procedure Code enacted in the 1908, the traces of arbitration is envisaged in section 89, where 89 talks about the alternative resolution mechanism, that is the backdrop of arbitration, that is the initiation of arbitration. Concept of arbitration is envisaged in section 89 of Civil Procedure Code, the resolution of dispute by the alternative method. But the vast and the extensive act of arbitration was enacted in 1940, that is called Indian Arbitration Act. Till 1996, when the extensive code of arbitration was enacted by the Parliament, that Act of 1940 was prevalent till that date. Till the 1996, when the Indian Arbitration Act was enacted by the Parliament, the Act of 1940 was prevailed, which was made by the British. In the Act of 1996, Parliament has given prominence to the arbitration. In the Indian context, if we say why the arbitration is required, despite of the presence of the well codified, well defined, well documented judicial system, yes, there is a requirement of arbitration. The reason for the arbitration is twofold in the Indian context. First, the traditional judicial system is cumbersome, lengthy, and expensive. And second, judiciary is overburdened with the work in India, where the commercial dispute involved between the parties cannot be decided as the urgent basis because of the overwork of judiciary, because of the overload of the judiciary. So, if the commercial dispute shall not be decided within the quick period of time, what will be the ramification of that? The ramification of that, the business will be standstill. Without the quick resolution of dispute or the fair resolution of dispute in less period of time with less expenses will not be provided to the parties concerned, then the entire exercise of adjudication of dispute shall be futile exercise. It will not achieve any purpose. It will delay the process. It will delay the process for years together. For years together, the dispute cannot be decided. So, it will be benefited by the parties. Okay, appoint a person or a group of persons to whom you believe, to whom you consented for appointment, to whom you consented for the adjudication of dispute, and adjudicate the dispute with the well codified system. This is the basic requirement of the arbitration in India. If we see the syllabus, as far as the examination point of view is concerned, there is no need of extensive study of the arbitration. We can precise that. We can chalk out the strategy to prepare the arbitration. How? Study the arbitration in section wise. Instead of reading a whole arbitration law, we will confine ourselves on the precise study. We will confine ourselves on the sections which is required, which is important one, from which question is generally asked for the examination point of view. See the section 7 arbitration agreement, section 8 reference for arbitration, section 9 interim measure, section 11 appointment of arbitrator, section 12 ground to challenge for appointment of arbitration, section 17 interim measure by the arbitrator, section 20 place of arbitration, section 21 commencement of the arbitral proceedings, section 34 setting aside the arbitration award, most important section, this is section 34, section 36 enforcement of arbitration award, section 37 appealable order. These are the sections. Beside this section, generally no question is asked. So we will confine on in and around this section. Among these, the most important section is section 34. Section 34 talks about the setting aside the arbitration. Before coming on section 34, we must know the differences between the mediation and the arbitration. In the mediation, settlement arrived between the parties by the aid and assistance of the mediator is not enforceable unless until ordered by the court by a decree. Whereas the award passed by the arbitrator appointed by the parties themselves with their consent is enforceable in law. Even the court interference is minimum on that aspect. Court cannot interfere unless called for by invoking section 34 by any of the parties. So basic essence of section 34 is that a party not being satisfied with the award passed by the arbitrator can come to the court and challenge the same by raising certain ground, the ground of illegality. The Honorable Supreme Court in the saw pipe case coined a phrase, a beautiful phrase, that is the public policy, an award passed by the arbitrator. If it is against the public policy of India, that can be ground of setting it aside under section 34. What is the public policy of India? Honorable Supreme Court has defined what is the public policy of India. If it is against the fundamental policy of Indian law, if it is against the interest of India, these are the public policy. Our parliament, in order to give importance to the arbitration, the parliament has amended the Arbitration Act and made it very extensive. In order to give importance to the law of arbitration in India, the parliament has introduced certain amendments by which the law of arbitration in India became much extensive, much codified, and far away from the ambiguity and absurdity. Parliament, while amending the arbitration law, inserted few sections in it, section 29A and section 29B. Section 29A says the completion of arbitration proceedings within 12 months from the date of the commencement of the arbitration, whereas section 29B talks about the fast track procedure. In section 34 also, by way of amendment of 2015, the parliament by way of amendment has incorporated few things in section 34. That is the public policy which was defined by the Honorable Supreme Court in the saw pipeline case was inserted extensively in section 34. In whole scheme of arbitration in India, the requirement of arbitration is very much necessary, because our traditional judicial system cannot cope with the rapid change in society, where the economic growth is rampant, where the economic growth is inevitable. Then its aspect is that where the economic growth is taking place in the fast pace, the dispute, the commercial dispute bound to be surface. If that commercial dispute shall not be decided by way of alternative mechanism, then the progress of India will be stopped. Even the Law Commission in several of its reports has recommended that at least commercial disputes should be taken out from the court, so that court can invest more and more time to impart justice to the needy person. Court should not be interfere in a commercial dispute where the large commercial interest is involved between the parties, and the large commercial dispute where the big corporation is involved should not be adjudicated in the civil court at the cost of public money. Rather, it should be decided by the alternative resolution mechanism, that is the arbitration. Poor country like India cannot invest that much of money in the judicial system. This vast country where the citizen is deprived from the basic necessities cannot afford to invest much in the judicial system. The way out is that if dispute arose between the big corporation, rich people, then it should be decided by the alternative resolution mechanism, that is the arbitration. The court should not be burdened with that commercial dispute. This is the need of India at the present day. Keeping in view the need of arbitration in the Indian context, the Parliament of India has amended the arbitration law by the Amending Act of 2015, which is very much necessary, by which the entire arbitration process, by which the ambiguity and absurdity, by which the ambiguity involved in the arbitration has been tried to be removed. Courts should not be burdened with the commercial dispute, and second, the court should not interfere in the arbitration proceedings involved between the parties for commercial dispute. So, reason is twofold. Alternative mechanism for resolution of dispute is required in India, as India cannot invest much in the judicial system due to the paucity of fund and the less budget allocation. So, the dispute should be defined. A line should be drawn where dispute should be divided: commercial dispute and non-commercial dispute. Commercial dispute necessarily be decided by the arbitration, and the non-commercial dispute be resolved by the traditional judicial system, by the civil court. If the new cases will not come for adjudication in the civil court, the pending cases will take years together to decide. So, court is not in a position to adjudicate the dispute which is a commercial in nature. So, why not commercial dispute be decided by a way of arbitration? For that purpose, amendment was done by the Parliament. For that purpose, the Parliament has amended the Arbitration Act to give it more weightage, to give it more arsenal, so that dispute can be resolved easily. The section which we have mentioned, 7 to 37, the few sections which are necessary from which the question is being asked. Instead of studying much more in the arbitration, the precise studies is beneficial for the examination point of view.